Unfortunately, I think it's the regrettable nature of politics these days, where the negative is what plays. You know, if you look at the direct mail pieces that I've put out that have my disclaimer on it, they've all been positive. They've all talked about economic development. They've all talked about growth and opportunity. So that's where I continue to try to stay. I will tell you, gentlemen, I don't even mention your names when I'm out on the campaign trail.
Okay, do we have a motion on the alternative portion of that particular motion as to
I have a comment before I make a motion,
okay?
which is if you file a lawsuit or you bring a claim such as you're doing for this commission, whatever you have pled, that is the most you can recover and that is the most you're able to pursue. So I think Mr. Brey's motion, although if we were in a court, he wouldn't have to make a motion, I think it needs to be limited in my motion. I would move that we limit the hearing as to the allegations and the complaints.
Well, and I think in the spirit of Mr. Hicks' request and comment regarding understanding the scope of what's going to be addressed in the future, that motion helps accomplish that.
I'd like to hear Mr. Richter's opinion.
I would tend to agree with that. I think this commission is responsible for complaints that are brought to it and for it, and the allegations that are contained therein, and that is what we make a finding on. If through this process, Mr. Hicks has come into other information that may invoke other elements, even though they're similar, he has an ability to file another complaint based on that information that he has subsequently developed. At least that would be the approach that I would take, and the approach I would recommend.
So, just sort of, so I can understand from a legal perspective, your view is that the statute would require that you specifically plead all of the items in violation. If discovery, if through discovery you discover more things than that, would should you amend your complaint to comply with the evidence? Or you're saying if it wasn't pled in your original complaint, you're not barred by res judicata for anything that you discover in this case that you might use and you refile in another?
Because, at least to me, because that would be a different set of facts and circumstances, separate and distinct from what was originally pled in the complaint, yes.
And I think it's the civil rules call for either seeking leave to amend your complaint, or if you're not time barred, you can automatically file the amendment, but we've not had any amended complaints to bring additional allegations.
And I will inject that as a general rule, because we have dealt so rarely with amended complaints, I will generally recommend that somebody file a separate and distinct complaint, which depending on when it is filed, we could consolidate in potentially, if, depending on when it is filed, or we conduct a separate preliminary review and hearing based on the second complaint and the evidence that's included therein.
Even if the violation is basically for this, it's the same, similar violation based on the same campaign report?
Yes, because it's a different set of, there are different facts and circumstances that would support it.
Yeah, okay, so I'm just, just as a,
Sure.
I'm just struggling a little bit with, if I file a complaint and I say you violated campaign finance law #1, and here are 6 examples, but I didn't name all the examples and I discover more through discovery. From your perspective, the complaint is limited to the 6 I cited, and I either have to amend my complaint to add more, or I would not be barred by res judicata for things that I discovered in this case on the allegation I complained about, to file a second thing for a similar violation for additional items that could have been brought up in my first one based on the discovery that I got.
But because they were not brought up
In
in
my
the
complaint.
original complaint, they are new and distinct and separate allegations.
Okay, and I can't do a motion to conform to the evidence or to conform to discovery to keep it in one place? I mean, it seems like counterintuitive to me, I'm just saying.
I guess the problem I perceive with that is due process to the respondent.
Right.
Whoever, all of a sudden you're hearing and they're bringing up brand new allegations that you didn't know were coming in your face.
Understood.
And I think that's the purpose for saying you've got to limit to the allegations being raised in the complaints.
Right. I get that part. My concern is about the next step. That at that point in time, are they barred from ever bringing those up again?
Hold on for a second until we exhaust comment on this, because.
My argument would be no, because it's not a matter that we had previously addressed.
But res judicata does, it means you did or should have, could have, and didn't. It doesn't mean just what you brought up. Res judicata will bar anything that was based on the same facts and circumstances that were also raised the first time. That's my understanding of it.
Okay,
But we're a statutory board, so maybe not.
well, that's
why I'm confused.
different than how we have ever operated
Okay.
in the past.
And I think there's also an issue of the discovery rule, knew or should have known. I mean, if you
Right.
don't know it, all of a sudden you discover it and you didn't have it before and couldn't have had it before, that would change whether you're barred from bringing that up again.
In the same or future litigation.
Correct.
Yeah. Okay, I'm just wondering.
Okay.
I mean, it's a very technical view, I think, but I get it too.
Right.
Mr. Hicks, your question or comment is on this particular issue?
Yes.
I suppose procedurally it would be Mr. Brey first, since it is his motion. Do you have anything further?
Well, I obviously support the motion. You know, I think that it's, one of the challenges we've had is knowing what it is we're arguing about. And keeping to the point, I think, is important for our due process. You know, yeah, there are a lot of exhibits, but, you know, who knows what actually Mr. Hicks, or he may not know what I'm gonna say, understand. But whatever we say, I think legally is required by both the statutes and the rules of this commission, rules of process, to be limited to what was pled.
Is your comment for this particular motion, or are you looking for guidance based on the way you see this going?
I think it's the comment on the particular motion. I think they a little bit blend together. So, am I allowed to comment?
1 minute.
Okay. So I just want to think of the preposterous notion. I'm going to get to a point of that what we're talking about we create would be, for example, that I've said 6 invoices under $18,000 and then immediately found that SMP said they paid $138,000. But now that can't be included because, you know, just the preposterous nature of, it's not as if I introduced, my allegations were massive media spending that was not reported and resources that were not reported. My allegation wasn't 6 invoices. Okay, and the actual affidavit requires you to separately specify the facts and evidence you have and what is the actual allegation you're making. And so I think my allegations, I have not gone off the script of the allegations that were in those 2 affidavits of massive media spend and resources not reported. Now, the notion also that as a citizen, I would have to keep refiling additional motions, it's just ridiculous, especially if we can't do these meetings on Zoom, okay? Just the amount of effort it takes to do something. So I would say that either his motion should be denied, because we already have the exhibits, you know what I'm gonna talk about. So it's not, doesn't go off the point, it was already submitted, his motion should be denied. If it's not gonna be denied, then I would ask that there would be a continuance of the whole case so that I can amend my complaint, so that I can make the complaint conform, so that I don't have to go through another year-long process to get to the same point we are right now. But the notion, I think it's a very dangerous notion, the concept that somebody makes a specific allegation, like, for example, unreported media spend has specific evidence, and then an investigation uncovers the exact numbers for that, but you can't consider the exact numbers. That doesn't make any sense to me. I'm not a lawyer. But it seems like a preposterous outcome for how the election commission would work if that were the manner in which it worked. It would say, why even do discovery? You have to know everything up front. Why even do discovery? To pinpoint the numbers and the facts. So that's so I recommend the motion be dismissed. But otherwise, I think that either the case should be continued so that I can amend my complaint, or this board should then, it's another serious issue like in the fifth, like pleading the fifth, is figure out, this is not a quick answer because it has long-term implications for the hearing of any complex case where evidence can come up during the investigation period that pinpoints numbers more accurately and what happens more accurately.
Okay,
Thank you.
Thank you very much.
May I respond to the motion he made as part of his remarks?
Well, I don't think we're gonna
Okay, fine.
let this gravitate toward outside of what we are dealing with, so. Is there a motion?
There was a motion placed to, to sustain the motion to limit to the elements in the complaint.
I'm going to withdraw my motion only because I think we need more discussion. When we're talking about a civil case, courts generally say leave shall be freely given to amend to make sure all allegations can be heard and brought before the court. And if Mr. Hicks is asking for leave to amend his complaint because there's more that he feels needs to be addressed, I think we as a commission should consider that. Because as we know, he's limited to what is being pled, and that's what the motion was. But if he believes that he has more evidence and he has more that needs to be amended to include the pleadings, or in this case, his complaint, I would be a proponent to say allow him to do so.
Go ahead.
May I respond to that suggestion? A motion to amend in connection with the Ohio Elections Commission would permit him to create new allegations without a new preliminary hearing. In other words, we would still have to go through a preliminary hearing in order to determine whether or not those new allegations were proper. And it would not actually save any time because we'd still have to be going through the same process. It would take the current pleadings and blow them up once again. This case has been going on for about a year. This is the fourth motions here we've had with the full commission, absent the recusal. It has cost my client a huge amount of money. We would like to get this case done. I would respectfully suggest that continuing this case and allowing additional amendments, when after all he can file a complaint if he wants to. And we'll deal with that, but he will then understand that when he files a complaint, he's limited to the facts of the complaint and can't do a bunch of discovery on things that aren't related to it or try things that aren't related to it. I would like to get this case done. It has been costly and prejudicial to my client in terms of time and energy, and to allow one more continuance so that something else can change entirely what this case is about would seriously prejudice my client, deny his due process rights to have this done in a timely manner.
If he files another complaint and files a motion to consolidate, doesn't that effectually do the exact same thing?
No, Your Honor, because if he filed a motion to consolidate in 2 weeks, hopefully this case is going to be done. And we're going to have maybe in 2 weeks we'll have another preliminary hearing, but otherwise the whole thing is kicked down the road. I don't want to kick it down the road. Obviously I can't force the commission to do it, but I would question whether it's really an interest of the commission to have this thing drag on any further than it's dragged. If there's another complaint, we'll try to get that. We'll try to deal with that as we can, but at least we'll know what it is, and at least we'll have a clear target of what to respond to. And what to allege in response to that. Because right now, we don't. And right now, giving a carte blanche to Mr. Hicks to amend it and not even, and continue this, who knows how long it'll be continued. Maybe we need more discovery on that. Maybe they need more discovery on that. But whatever happens, if we allow a continuance and amendment, we're not going to try the current case in 2 weeks, and we're not going to get done with it.
Am I able to respond?
Hold on. With that being said, would you want to withdraw your motion to limit?
I would not. I have a constitutional and statutory right to limit the case to what is in the complaint, and I have no intention of withdrawing it.
Can I respond? I think there's a little bit needs to be seen through. Mr. Brey wants to save his client money by having me file extra complaints, extra affidavits. It doesn't make any sense. The allegations in this have been very clear. Massive media spend, resources that weren't reported. I've never deviated from those allegations. I've never added other allegations. I've never put things. So the notion, this motion was filed on September 17th. September 17th. If this was an issue, why wasn't this motion filed months ago to do this? This is just a tactic because of the imminence of the hearing. And I think it's just a very dangerous path that you have can I finish my remarks now? I just want to have equal time as Mr. Brey when we're talking. So I'll take less, I'll try to take less. But the notion that, I keep bringing forward my allegation in the affidavit, I'm not a lawyer, so if there was something criminal that happened, you had affidavits from 7 people that saw different things happening, they would boil down to an allegation that would be investigated by the police and somebody would be charged. The notion, this probably is not accurate, but I want to me that would be kind of like saying, well, if there's something that came up in the investigation that shed light on something that was in the affidavit of different policemen, we can't consider that because it had to be. So I think the affidavit provides an allegation. It's statutorily required that, or your rules require that it has to have what's the personal knowledge and what's the specific allegation. The allegations were about massive media spend that wasn't reported and about resources not reported. I think I've stuck completely to that. The irony of this is, since August 11th, you've all had my exhibits. He's had my exhibits. You know exactly what I'm going to talk about, what I'm going to focus on. I think that if Mr. Brey wants to use this tactic to hamstring under the guise that he's going to save his client money by making me file additional things, I think it's fair for me, because those additional things would take time, and you know I will absolutely do it. So I think then either this should be denied, you already have the exhibits, there was already an order around this to deny it, but otherwise, I want time I don't want to have to do a whole different set of streams of cases and preliminary reviews, and you probably don't want to see me coming here doing cases and preliminary reviews. So it would certainly save his client time, energy, and money then to give me time to amend a complaint so that this can be properly and fully considered. And the net result is that it's going to just take more time. Either way, either I'm filing more affidavits, or I amend an affidavit. It's just adding to all this, and it's a day late and a dollar short. I think it should be denied because for my allegations have never changed, and you've already had my exhibits for more than a month.
Well, I differ with you only in that, and I don't want to speak for Mr. Brey, but I'm guessing he filed his motion because he wanted to limit you so you don't continue to go off on the reservation on all of these different issues which don't pertain to what you have actually put in your complaints. If you are sitting here and you're honestly telling this commission you believe there are more allegations that you need to amend your complaint to actually bring in, then I would not be opposed to granting leave to amend. If you're looking to just extend this hearing and keep doing a bunch of stuff and going off the reservation, I'm telling you as a matter of law, you at this stage, I believe, are subject to only which appears in your complaints.
The allegations or the specific evidence I have?
The allegations, what you have raised as the violations in your complaints.
So the allegations of my complaint wasn't 6 invoices. The allegation of my complaint was that there was massive media spend that was not reported.
I'm not looking for a debate. I'm asking you, do you believe you need to raise additional allegations in an additional complaint, or are you comfortable living with the allegations you have raised in the complaints you have filed?
If the allegations, you're confused.
You're not answering my question.
Because I'm confused on the question. Can I ask for clarification on the question?
You have filed 2 complaints. And what you have set forth in those complaints are what we as a commission are going to hear. That's it.
But his definition of that is 6 invoices. My definition of that is massive media spend that was not reported. That's why I'm confused by you asking your question in that way. So the definition that I think is that my allegation was massive media spend that was not reported. My allegation was resources that were being used that were not reported. That was my allegation. I offered evidence. You get into the circular reference. Was I supposed to offer evidence I didn't have? that then he would say wasn't personal knowledge that I put in an affidavit?
So we
So-
can't provide legal counsel to you. What you need to do is
You
either
can't ask a clear question.
hire counsel to assist you, or know that if you proceed forward, I'm gonna make a motion that you're limited to what is listed as the allegations in your complaints.
The allegations or just 6 invoices? What does it
I'm
mean?
not here to provide counsel to you. I'm telling you what we as a commission are capable of doing.
And I would ask, maybe you should all pause and read your own mission. The notion that you won't answer a question is, does your motion mean the 6 invoices only, or the allegation of massive media spend? And to tell me I should go hire a lawyer to get an answer to that question, I think defeats the purpose of this being a body that's supposed to be making it easy to get resolution, a proper and fair resolution on campaign finance issues.
We're here to make decisions. We're not here to provide advice to you.
Can somebody
But your
answer?
simple question is, what is the definition of an allegation
Right.
in this particular?
6 invoices or
Is that-
massive media
No,
spend?
no, no, not the fact. I was
Right.
saying, you're asking, is an allegation the claim of of wrongdoing generally, as in the statute? Or is it allegation means a specific subset of facts? Is that the question that you're asking? I'm
Correct.
using your
And I
example.
pointed out that your own rules say that an affidavit has to have what was your personal knowledge, and then what is your allegation? And what code sections did you believe were violated that supported by your evidence? Then when you do a preliminary review, there's discovery and investigation, and if we were to go down this path, if things came out in discovery and investigation, like that the actual amount was $138,000, not $118,000, the logic would be that the complainant has to refile something, or has to amend something, or has to do something. I was unaware, this has only come up since September 17th, when he filed this motion, okay, this part about limiting. It's already come up a couple times when you had the order, when he was trying to get behind the scenes, get rid of certain important things, and Mr. Richter issued an order. So, you know, the key thing here for me is that definition of what's the allegation. And I know I'm seeming like a broken record, and I apologize, but I've never gone off the script of the 2 things that were my actual allegations. Right, what's happened is more evidence has come to light in discovery, like that it was, like that strategic media said it was 138, not 118.
Then I believe you answered your own question. What is an allegation, what is evidence? I mean, as a layperson. So if, you know, Mr. Norman is directing you to kind of investigate what an allegation truly means, and Mr. You know, Vice Chair Beatty is as well, I think that that's the answer. So we can belabor it for an hour or more, or we can, you
Well,
know.
I just want to make a quick comment. I apologize, but, you know, he's got a lot of words in his thing, so when you're making motions and agreeing to something, I'm very careful about what might be in something that he wrote in something that was submitted on the 17th, that may create an implication that's not maybe the intent of this commission as to what it means. So I think you need to be specific, because he's made representations in his filing as to what these things mean. And a vote that to accept that might be implied is meaning whatever he said in his thing is true, accurate, fair, and correct.
May I just respond briefly? This is a quasi-civil, quasi-criminal proceeding, and therefore respondent, who is potentially charged with criminal conduct, has a right to know not just the statute, but the factual basis for that. The rules of this commission require that, as well as the statute, that there be a prima facie case, which is facts, that support an allegation of the statutory violation. In a criminal case, if I were accused of breaking into Mr. Smith's house, and they found in the course of their investigation, they also broke into Mr. Jones's house, they would not be able to present evidence and convict me of breaking into Mr. Jones's house at the criminal trial in which the criminal complaint accused me of breaking into Mr. Smith's house. And it would violate all kinds of due process to require me to do that as someone who is potentially facing, you know, criminal referral. I don't think that the amendment process, I think the reason the amendment process has not been used often in the Ohio Elections Commission is because it's inconsistent with the rules of proceeding in the Elections Commission, unless both sides agree to that, which we're not here. because the rules of this commission require that you make a new allegation of new factual basis for violation, that you have a new proceeding. You might be able to consolidate them if the timing works out for them. And by the way, if he does make new allegations, new complaints, we would have an opportunity to try to knock them out and to defend against them at a preliminary review. And frankly, we're more than willing to take our chances on doing that. But that's not going to happen if he somehow is able to avoid the procedural requirements of a new allegation by amending it or in the guise of amending it, avert the need to present that factual argument in front of the board before anything else happens.
Potentially that, though, raises if they're not consolidated, you have two hearings with the same set of facts, the same set of witnesses, and this commission is, instead of consolidating, having basically to serve the jury on two separate occasions with different commissioners. Because at the end of the year, you're going to have three commissioners who are leaving this commission. And so it seems to me that either you file your complaint, consolidate, or you amend, it's the same result. I think this hearing, if Mr. Hicks actually intends on filing an additional complaint or seeking leave to amend, it should be granted so that you're not getting inconsistent results with different commissions.
I have a 30-second response to that. So he gave the example of Mr. Smith's house and Mr. Jones' house. Great example, I love it. If I broke into Mr. Smith's house and stole a bunch of stuff, and then Mr. Smith reported in an affidavit to the police, these are the things that were taken out of my house, and then later it was found, oh, the guy that robbed your house also had a diamond ring. Oh yeah, that was my diamond ring, I didn't list it in my affidavit. I don't know the answer to the question, would it say like, well, we can't do anything about that. He gets to keep the diamond ring. We're not talking about unrelated things. We're talking about a very straightforward allegation of media spend, all involving the same people, S&P, Alan Freeman, etc. The other thing is he said, prima facie case. So I don't know what that meant exactly. I know what it means generally, but so last time we were here, he was arguing about an affidavit needing to show just probable cause. So the different use of definitions, obviously my affidavit showed probable cause in a preliminary review phase, and then there was discovery and an investigation, and then that just shed light on the exact allegations that were in there, like that it was 138,000 versus 118,000. The idea that requires different complaints, consolidated complaints, that you always have to amend if you find something, would make, look at how this case has worked. It would make things here take decades to get anything done. And so I think the right answer is just to deny the motion, but like I said, if you're not going to deny it, then I want to have the opportunity to consolidate, so I don't have to go through everything all over again for a year. That I'd rather take more time and get it all consolidated now. But I think the right answer is to deny the motion.
Okay, hold on.
Go ahead, I'm sorry, I didn't mean to interrupt.
No, go ahead.
I think you need to reflect on what you're saying, Mr. Hicks, because if you're saying we should deny the motion, I think as a matter of law, you are bound by what is in your complaints. And so if you want to proceed with what's in your complaints, that's your choice. If you feel there's more that needs to be added to your complaints, then you either need to seek leave to amend or tell this commission that you'd like a continuance because you're going to file an additional complaint and you're going to ask to consolidate.
I think this is our confusion on, my allegation was massive media spend. I presented information to gain probable cause. Then there was discovery and investigation. We found things like that instead of 118,000 as 138,000. The notion that requires all this extra work would make this commission unable to function.
Okay.
Well, we functioned for years.
I think these kind of cases, you're probably good with these, the LaRose referrals and stuff like that. I've said before, this is a canary in a coal mine of more complex cases where these factors come into play. And I think that for the state of Ohio, and given the issues that have happened in campaign finance, beyond this case, this commission needs to figure out how it's going to deal with those kind of things, because we desperately need a commission that can deal with these kind of more complex cases.
Mr. Hicks, it's pretty simple here as we sit here looking at you. You either need to say, I'm prepared to proceed with my complaint as it's prepared, or I'm asking to amend, or I'm going to file an additional complaint. That's the only issue facing you right now. I don't want to hear any more argument about what else is the facts and the change in money. What do you want to do? What do you intend to do?
Okay. I am prepared to proceed with the exhibits in the case that I have already had to submit on August 11th by order of this commission. I have had no objection from him or anybody else about what I submitted for that, and so that's what I'm prepared to proceed with.
That was not one of the two things I think that Commissioner Norman said. And clearly, Mr. Brey is objecting to those because he has a motion today to limit you to a complaint and the 7 invoices attached to that. That's what's before that commission, 6. If we grant his motion, you're limited to a complaint and 6 invoices.
Well, he just said if
If
you
we
deny the
grant-
motion, then I'm limited to that. So I'm being as simple as I can. I'm not a lawyer, I'm a lay person. I think this commission needs to give latitude, but it needs to work. It needs to work for, you need to look at what the mission says for this
So,
commission.
okay, stop. The latitude we're giving you is this, 2 choices. 1, we'll rule on the motion, and if we grant it, you're limited to the complaint and 6 invoices. If we grant his motion.
Okay,
Or Mr. Norman is saying, if you're saying, that's not what I want, you can make a motion to continue the case and leave to amend or to file an additional complaint.
if you deny his motion, so you said if you grant
no.
his motion.
No, this is not a debate, I'm telling you. His motion is to limit the hearing to the items specified in the complaint. If we grant that motion,
Yeah.
you are limited to the items specified in the complaint and 6 invoices.
I think you should deny that motion.
Okay, if we deny the motion, Commissioner Norman is saying, you're gonna be limited to what's in the complaint.
So you're just saying it's the same thing, deny and
That's
accept
what
is
he
the
thinks
same
the
thing.
law says.
Okay.
And let me tell you, Mr. Hicks, that is a motion I would put forward before this commission if you are not seeking a continuance or a motion to amend. I just need an answer because I'm ready to put forth my
What you're
motion.
saying, so I just want to be clear, no matter whether you deny or don't the motion, what I've just had explained to me.
You haven't heard his
It's
motion
the
yet.
same result. So I think, I do whatever you want. I think Ohio needs to see how this commission is going to work. And the notion, for example, that I've said it again and again, my allegations were very simple. Massive media spend that wasn't reported and resources that weren't reported on any campaign finance report. I presented probable cause in an affidavit and a preliminary review. I provided evidence and I made those specific allegations. In the discovery period, we discovered that the number, for example, was 138, not 118. Somehow that's some complex thing that we have to, that either I have to amend, I have to do this, I have to do that. Do whatever you want. I feel that the case should proceed with with the allegations, which is massive media spend and resources not reported, and the evidence that is obtained during discovery and investigation. The notion that that needs to create a new case or a case consolidation to me would be an absurdity.
That's the law. And I'm giving you the chance to unring the bell before I ring the bell and say,
Do whatever you want, Mr. Norman.
I'm giving the opportunity, and I'm gonna put it here on the record, I'm giving the opportunity to ask this commission for the opportunity to amend my complaint or file an additional complaint should I think there are allegations. If not, I'm prepared to proceed with a motion.
Well, I would wish to be able to file additional complaints. So we keep adding extra little things.
That's already been discussed earlier in the very beginning.
So would your action on this
Executive
motion have any impact on my ability to file additional complaints?
Director- No, and that's what the executive director explained in the back and forth among the commission about how this could potentially play out.
So in theory, just a point of
Well,
clarification, I could
it's really
withdraw my
defined.
complaint and file a whole new complaint
You could.
Yes.
after you make whatever decision you have here. I just think you guys need to talk without us talking about the what's the intent of how this, you look at your mission and the idea of what you're supposed to do. It's just to figure out how you want this to work going forward, because I think the notion that 118 versus 138 is my great example, that this requires this kind of discussion for this long is a point of absurdity.
Just one point, I fully support his suggestion that he withdraw his complaint.
You know one's coming back, so that you're interested in saving your client money supposedly.
What, can I ask you a question as a layperson? What is the difference between withdrawing and then submitting a new or amending? So if he amends, is that maybe not as laborious,
Same process.
Same process.
It would essentially be the same process, yeah. I mean, we would still have to, the commission would still have to take it up under preliminary review and assess the elements of those complaints.
But you would
Nothing has
have-
to be withdrawn.
But you would have the discovery, you know,
Presumably complete.
complete in the case. Versus, there's always an issue if you have discovered in one case, how that would translate to a new case, and if there are new allegations. It could get bigger, it could get smaller. So those are,
But we have knowledge. If you amend, then at least we have the basis of the complaint, and we're just adding whatever has been discovered in the meantime.
that's one, yeah.
Okay,
That
and I mean,
could be
very,
the
very
case.
much a layperson's take
Yeah,
on it.
that
Okay.
could be the case.
Okay.
Or it could be an additional complaint.
Right.
And if it's not consolidated, then you're talking about having the same witnesses, the same set of facts, and everything decided by a completely different set of the commission.
And possibly all discovery all over again.
Well, judges lose elections and
They move on.
and cases will go on, so. you know.
You're also, very quickly, you're setting a precedent that says, expect a lot more complaints. Because anytime somebody finds something that it was 138 versus 118, new complaint. So it's.
Mr. Hicks, we understand your arguments. At this
Okay.
point, it's before the commission.
Okay.
We're not taking any more arguments of council. I hate to cut you off, but we're not advancing the ball here. We're flogging a dead horse, so let's just move on.
Mr. Hicks keeps bringing up about the difference in the amounts. If you look at the motion, it says motion to limit the hearing to items contained in the complaint. We know what items are in his complaint. If he should find before we go to hearing, full hearing, that he has new information, but it's within those items, we're saying he can't bring it up if we pass this motion.
Right,
And that's called due process to the respondent,
right,
who is now facing a quasi-criminal.
right. He's entitled to know what he's being charged with, basically.
You're not entitled to show up with surprises.
Right, so
Okay.
if you're accused of something, you are entitled to know specifically what you're accused of
For that complaint.
from that complaint.
Absolutely.
That doesn't mean that if things come up, you can amend or file anew or whatever. But, yeah,
And that's not, this is the law. This is how this commission functions, that's how the law
well, that's
is.
why I looked to Mr. Richter
Yeah.
about the history of the commission, how it's functioned. And Mr. Richter, can you weigh in? You got any other insight at this point?
I mean, I don't know if this case is any more complex than any other case the commission has ever had. There are campaign finance allegations, and there's, this has either been established or not. And so I don't see this as being any more complex than any other matter that the commission has handled. And, the facts will be brought forth, to me at least. The complaint says what it says. It does allege that there are violations of, 13B, 10D, about keeping account of all contributions and expenditures. That's those receipts are the elements of the basic elements of the complaint. There's other information that might be beneficial to the commission to help it make a decision. I see those as being something that could be submitted to the commission as establishing, whether it's been a violation or not. That's the way I view this coming forward. I don't think I'm wrong, or I don't think that I'm stepping on somebody's due process in terms of how this goes forward. But the allegations that have been presented is that there have been problems, let's put it that way, with campaign finance reporting, and if we get evidence that establishes that, then we make a decision that says that's the case. If there is not sufficient evidence to go beyond what is alleged in the complaint, then we find no violation based on what evidence is presented to the commission. That's my view of how this thing should go forward. And so I guess I look at it as we're limiting what's in the complaint. what's in the complaint. Community Director Alan Freeman failed to account for media expenditures on his campaign finance statements in violation of 351713B and 10D2. That's what the commission has before it.
Not specific amounts and not specific invoices.
I mean, there are specific amounts included in certain elements in here, yes. But to me, that's what the commission is assessing. And I appreciate what Mr. Brey says about believe as opposed to personal knowledge, et cetera. Saying, I believe that Mr. Freeman failed to account. But with all of the other elements involved in this complaint, research of the records, et cetera, brought forward, you know, we have certain elements of the complaint brought to us in terms of here's you know, here are media amounts that are out there that supposedly have been established for this campaign. And there were only supposedly so many expenditures made. There's a discrepancy there. Can that discrepancy be established in the evidence that's presented to the commission, or not?
There was also this other affidavit that had a slightly different allegation, because there were two affidavits.
I appreciate that. I was only talking about that, but that's what I was talking about.
So I guess, there's a noticeable lack of conversation here. That last issue I raised about if additional information should have come into Mr. Hicks's personage, if you will, that has a direct nexus to his initial and original items. We're saying by this motion, he's limited to bringing that information up, but he has an avenue to file a new complaint
Correct.
on that new information. Do we all agree with that?
I would agree with that, although if I were sitting in Mr. Brey's chair, and again, I don't want to speak for Mr. Brey, if new allegations were brought forth, I'm sure there will be a motion to dismiss based on res judicata saying, if you knew or should have known this, you should have brought it the first time, and you did not. And therefore, you're precluded from bringing that before this commission.
And that might be the eventual outcome, but Mr. Hicks still has a right to pursue a new allegation.
Anybody can file a complaint.
Then I would think, Mr. Co-Chair, we've exhausted this, and I think it's time for the commission to make a decision on Mr. Brey's motion.
Is there a motion? Because I thought Mr. Norman drew.
He withdrew his motion.
Right.
There's no motion currently pending on the floor.
I did.
No, there's nothing pending yet because.
I don't think you had a second.
Do you have any motion?
Because we ruled on the motion to dismiss for lack of personal knowledge.
So the motion that Mr. Norman made was withdrawn, which means a new motion is in order. And I would make that new motion, and I would make the motion to limit the hearing to items contained in the complaint.
Is there a second?
I just want to clarify because I think there are actually two complaints. Am I correct?
There are two complaints
That have been consolidated.
consolidated into one document, more or less, yes.
If that is the motion for those, as Mr. Bromer's put it, but to both those complaints as consolidated, I would second the motion.
Roll call, please, Mr. Executive Director.
Thank you. Ms. Cunningham?
No.
Ms. Tavares?
No.
Ms. Kaufman?
No.
Mr. Norman?
Yes.
Mr. Bromer?
Yes.
Chair Beatty?
Yes.
Vice Chair Beatty? That motion does not pass. It is tied 3-3.
3-3.
outstanding. Move on. It has not been approved, so therefore,
Or isn't it denied then?
historically, that is what the commission has done, yes. As there was no action to go forward, the commission has essentially denied the motion administratively.
Before we proceed, could we have a 5-minute break? I'm requesting a 5-minute break.
Make it 7.
7 minutes, all right.
Thank you.
Now, the nice thing I know is
I have a question.
I'm not working out for it. I know how it works in my trust. Don't read off the piece. I'm just saying, hey, listen, we got everything we needed. Any comments? No, what's approved?
All right.
So that, so there's still one thing that passes. No.
That's what I figured.
Is it okay? Meeting, but there was so much to do to set up and get things ready, and I didn't get a chance to talk with you before.
That's okay. I was running behind anyway, too, so I got here at like 7 minutes.
Trying to adjust
So
what
I just
I-
want to kind of.
Yeah.
No, but it's good, you know, it's,
Yeah.
I gave you a copy of the summary page which has the
Okay.
names of all the parties.
Thank you.
So.
No, I just wondered.
Oh, see it. Yeah. I got it.
Just say if you need another one, you know, I think
No,
we're
we're
there in the office. There's one right here as well.
Right.
Okay.
Right. I would, you know.
Battery low, or are you paranoid?
I
My battery's fine, but I get paranoid that it's suddenly gonna go to 0 and go so.
I don't know.
That way it's clear, I don't see that. Preclude you from being able to do this game.
Okay.
Oh, I know. I really would be guessing as to what the evidence